exactly what the expert suggested they should have followed in terms of the principle that the defendant wanted to establish with expert testimony.
You're not suggesting that the expert would have been limited to what's on that proffer sheet, are you?
No, it's not that the expert would have been limited. It's that this is all the defendant proffered, and this is what Judge Wetzel ruled on.
But what I'm asking you is, you don't think that the expert would be limited to simply testifying as to what's on that sheet, do you?
No, I don't think the expert would be limited if either with or without a Fry hearing, the expert gets on the stand. The expert is going to testify about a lot of things. But Judge Wetzel's ruling has to be evaluated based on what was in front of him in terms of a proffer. And with this proffer in front of him, Judge Wetzel was entirely correct for saying, hey, what do we need an expert if all you want to show is that confidence level is not a good predictor of identification accuracy? I believe that. I'm with you. I'll charge the jury on that. What do we need an expert for?
Well, are you equating a jury charge to expert testimony?
To the extent that the jury charge covered what the defendant proposed to have the expert establish before the jury.
What page is that you're referring to?
This is page A197 of the appendix.
Where in the charge does it say not, I'm sorry.
Yeah, what page is the charge on?
Oh, I'm sorry. The charge is A174 and 75.
And does it say not a good predictor in there?
It says no guarantee. It says entirely possible. It says you may not rely on confidence. It says you must instead make your own determination of accuracy.
Do you see any difference between that and not a good predictor?
I think it's reiterated several times, and I think not a good predictor and no guarantee are very similar. And you must make your own determination. You may not rely on the witness's confidence. I think communicates the message quite effectively that confidence is not a good predictor.
Okay. Thank you, counsel. Mr. Pomeroy, brief rebuttal.
Thank you, Your Honor. I just want to address the issue of corroboration, which is where we left off. Because as you noted, Your Honor, the First Department said, after it went through their arguments, essentially it said, but we assume for the sake of argument that there would have been a violation of Legrand, but let's look at the corroboration. You have the first issue, just to touch on for a second, which is that put aside the log sheet, the extrinsic log sheet. When the people's case closed here, there was no evidence other than that eyewitness identification. But let us assume, even for the sake of argument, that you would look at all of the evidence, including the defendant's case. Let us then, you will have to read the testimony of Ms. Nimmons and Ms. Murphy and look at the documents instead of looking at the descriptions that either of us put in. When you look, first it was Ms. Nimmons said. Ms. Nimmons, yes, is his fiancée. They make a wonderful point about talking about all their family members and what have you have an incentive to lie for the defendant. When you have a family barbecue and your alibi is at your family barbecue, it shouldn't shock anyone that the four witnesses that testify are related to your family. What Ms. Nimmons says, and to show that this issue of their sole issue, and the sole issue the First Department said was corroborative, is that there was testimony that the June 2nd sign-out sheet was picked up by Ms. Nimmons, his fiancée, on June 3rd. Okay? I note first that that is consciousness of guilt evidence. It is not, as this court wrote in Legrand, evidence connecting the defendant.
But consciousness of guilt evidence before you're accused of something is really pretty probative.
And I want to get to the facts, Your Honor, because this literally will come down to, I don't want you to assume, when you look at this testimony, you will not assume that that is in fact what happened. Let's look at what Ms. Nimmons said. It is page 155 of the appendix, page 459. When she is asked on a leading question by the prosecutor, quote, you went to your daughter's school on June 3rd, the day after, to pick up the log. Answer, yes, I did.
But didn't Ms. Murphy testify that they said, how do you remember the day? When you say you saw him to come in and sign her out, how do you remember the day? And she said, oh, it was the day after the crime.
Your Honor, she did not, Your Honor. Let me, if I can finish Ms. Nimmons, because I think you have to look at Ms. Murphy's testimony and the fact that to these witnesses, the centrality of what day this log sheet was picked up. An assistant teacher at a kindergarten is not, as we all are today in Albany, focused on what day it was picked up. But let's look at her testimony. On cross, she says explicitly, yes, I did, under oath. The very next question, and why did you pick up that log? Answer, because when Mr. Abney was arrested, he called me and he says that, quote, they're saying that I committed something on June 2nd.
I'm more bothered by the Murphy testimony than Nimmons.
I'm sorry?
What day was he arrested?
June 22nd. Okay, so in that very question and answer, it shows that when when someone gets asked, and you picked it up on June 3rd, she wasn't focusing on was it June 3rd.
On the date. She was
She
focusing
focused
on
that she
a
picked it up.
time after the arrest.
Now, when you look at Miss Murphy, the teacher, and Your Honor suggested before, you may be may I continue?
All right.
Your Honor
One
suggested.
sentence, finish the sentence, and then I have to cut you off.
Your Honor suggested before that even Miss Murphy or someone at the school might be in cahoots. Miss Murphy was the one who said first that it was on June 3rd. If she was in cahoots, if she was the one who created this
Okay. Oh, you
document.
started a new sentence.
Can
All right.
I get your indulgence for one more question?
I shouldn't cut you off either, huh? All right, go ahead.
How do you account for the existence of two sign-in sheets?
Pure and simple is a mistake, Your Honor. And I just note the originals, it was a mistake by somebody at the school. Those sheets, when you look at them, they're not done perfectly. They're not, briefs that are filed in this court. The important thing there, the originals of both those sheets, our clients never saw them. The school testified. There's no evidence other than the school had all of those sheets under lock and key.
Okay. Thank you so
Thank
much,
you very much.
counsel. All right, Ms. Calico. All right, Ms. Calico, good morning. Good afternoon.
Good
I'm
afternoon,
sorry.
Your
Will
Honor.
you be reserving time?
3 minutes, please. 3 minutes, please, Your Honor.
For you also? Okay. Yes. Go ahead.
In this case, 2 men wearing ski masks robbed a barber shop in Queens. Only a small portion of the face of the shorter robber was visible. The 2 men were carrying weapons. The witnesses testified about a gun in the hands of the taller robber, and specifically about a sound that was made when the slide of the gun was pulled back. One of the witnesses...
If you know somebody, even if they're wearing a mask, you can recognize them by certain other features and
In this
distinctive
case, there was
characteristics.
at most a passing familiarity with the person who they thought that it was, Junior, someone who they saw outside the barber shop on numerous occasions. The testimony was they had never spoken to that person. We don't know if they had ever come face to face. To assume that this was actually
You do have, though, 2 people who immediately associate a name with the person coming in. And then you've got some other factors that are discovered later on.
It wasn't really 2 people. If you look at the facts of the case, there was one person, Beard, who's getting his hair cut, looks in the mirror, sees the events unfolding in the mirror, sees...
The other person, Juan, picks him out also in the
But
mugshot book,
prior
doesn't he?
prior to the police going to the barber shop, we have testimony that Mr. Beard told people in the barber shop who he thought it was. If he had said, it's that guy who's sitting outside of the barber shop, we see him on Mondays, then Mr. Almonte's testimony, if there had been an expert, would have been much less reliable. If the jury had heard about post-event information, they would have thought, he heard who it was after the fact, then he's shown pictures where only one person...
Assuming that you could, that an expert could raise doubt about Mr. Almonte's testimony, isn't Mr. Beard's testimony in itself corroboration? And isn't he...
No, it's not corroboration. If the expert had been permitted to testify about unconscious transference, which in many ways is the crux of this case, when an innocent but familiar person is identified as the culprit...
Is it really unconscious transference when at the time of the event you say to yourself, oh, I know that guy, that's Junior?
Many of the studies have found that there's a lot of research on unconscious transference. Many of the studies has found that the mistake occurs at encoding. The mistake occurs at the moment that it happens, which is why the expert testimony in this case was so important as a safeguard against misidentification.
What about the voice? It was more, though, than just he recognized what he looked like.
Well, interestingly, in the studies...
He also said the voice.
The studies
And we're
regarding...
starting to put layer upon layer upon layer.
But I think these are false layers, Your Honor. I think that there's misconceptions about how we identify people, especially in the unconscious transference realm. The studies that have been found to find the most correlation with unconscious transference phenomenon find that there's a temporal contiguity, there's a familiarity, there was nothing distinctive.
Are you really saying that you've got expert testimony that can pass the Frye test that will say, when I am a victim of a crime and I see and hear the perpetrator and think I recognize him, that's unlikely to be right? Or that it's highly likely that that's not reliable?
I think it's possible, that it's unreliable?
You don't have that kind of expert, you don't have studies that show that in the record,
I
do you?
think the actual studies were not testified, were not explained by the defense counsel at trial, but they are actually in the record in that they're in the curriculum vitae of Professor Penrod, who's one of the preeminent scholars in this area, and whose research much of this is based on. But we're not just relying on Penrod. In the Casson survey, 80% of those solicited said that unconscious transference is reliable. Since that time, there have been cases where Fry hearings are held where they have found it's 97%
Well,
reliable.
but I mean, aren't at least some of those cases, I would have thought maybe all of them, cases where at first you don't know who it is and you're thinking, and after the event, you're thinking, oh, I know who that was. That was Junior. That's different. This is a guy who looks at, oh, that's Junior.
It's not the scenario that you just posited, Your Honor. I think many of those cases regard mugshot bias and situations where you see the person in the lineup and then are convinced after the lineup that the person is the person who was the culprit. Some of those cases in the studies do show that.
Here. I mean, here, the name Junior or JR was actually given to the police at the time of.
Because that's the person
incident.
who Beard thought it was. When this person comes into the barbershop, the shorter robber comes into the barbershop, we have to remember.
But how did it happen that Beard got the nickname right?
Because he knew the guy on the street.
No, but it's your client's nickname too.
But he was misidentifying the guy on the street. See, I realize
No,
this
but if your theory is there are two guys. One is the Junior that Beard was thinking of, and the other is your client.
No,
right?
there's the shorter robber.
No, I'm not. Yeah, there's a shorter robber, and there's somebody named Junior known to the witness.
Right.
And you say the jury might find them to be two separate people. My question is, isn't it a coincidence they're both named Junior?
No, the point is that Beard knew this guy who he sometimes saw on the street. He had never spoken to him. He had heard his voice 5 times.
But he knew him as Junior.
That guy is Junior. That's Mr. Allen. The guy on the street is Mr. Allen. A shorter robber whose face, all he can see is this portion of his face under a ski mask, comes into the barbershop.
I see your point.
And he's making the mistake that this guy is Junior. We had the temporal contiguity. We have the fact that Junior, Mr. Allen, is a guy who hangs around in this area. He has a girlfriend in this area.
What corroborating evidence could the judge have looked at in determining whether or not this was a Legrand case?
The only
Because, I mean, you do have your client saying, I'm not going to get in the lineup unless everybody puts on a face
Right.
mask.
I think
And the people are claiming the police never told him a face mask was involved.
one
That's-
police officer testified.
That's pretty inculpatory statement, isn't
I
it?
think there was a very fair inference from the evidence in this case that there was one of the other police officers told him that, or he heard them talking. First of all, at his apartment, when he's arrested, there were at least 5 police officers, and there were 4 or 5 parole officers.
You're saying he may have heard it. He may have heard
Absolutely.
from somebody that masked men came in and
Absolutely. In
robbed his
fact,
barbershop.
And you've got the jacket. He didn't want to put the jacket on, and then they found all the singles in the pocket of the jacket.
first of all, the jacket was never admitted into evidence. The judge found that it was not relevant because there was in the description of the shorter robber, there was no jacket. $400 were supposedly stolen at the barbershop in all different denominations. Under that theory, any jacket with any amount of money could have arguably been proceeds of the crime. I think I just wanted to point out that Detective Butel, when he was testifying that he did not tell the defendant about the ski masks, he was not the officer who described the crime to the parole officer. It was Sergeant Buell, who did not testify, who in fact told the facts of the crime to the parole officer. The parole officer and 4 other officers were alone in the apartment prior to bringing the defendant out.
So your posture is there is no other corroborating evidence. Is that,
I think that
Position?
even if that was seen as arguably corroborative, it's so unreliable, it's so equivocal that the identification in this case is still the central issue in the case, and the jury, not understanding a counterintuitive concept like unconscious transference, is evaluating identification with common sense misconceptions. This is exactly the situation where expert testimony is essential to rebut those